Are you going to appeal the judgment of Justice Hanson where he declared your sale and purchase agreements null and void?
Yeah, I certainly am, Lily. I've been writing their notice of appeal that has to be in 20 working days after the judgment, and so I got that in on time, and I got notice back from the Court of Appeal in Wellington yesterday that they have that notice, and I have another little while to ask for a hearing now. I've got 6 months to ask for a hearing, but I will do that in the near future because I got a very good piece of news on the 4th of came out of the 4th of July, which is quite significant, and it's a judgment that was made up in Whangarei. It wasn't my case, but it does concern some of the things I've been doing with sale and purchase agreements. It's a judgment by Justice Bell.
What's the judgment of Justice Bell about?
Well, that's the judgment I would have hoped to have got from Justice Hanson, actually, when I wanted my sale and purchase agreements to be declared, not to be declared null and void, actually validated, and that didn't happen. And but Justice Bell was looking at another sale and purchase agreement that I had concluded with some people. The people's name are Waterhouse, and the case is called Waterhouse versus Westpac, and Westpac were the bank involved, and I had done a $1 sale and purchase agreement, which I always make it for $1, and that wasn't called into question at all. And in that judgment, Justice Bell makes it clear that, one, not only are the interests of the vendor or freeholder separate from the bank's interests, but that the sale and purchase agreement was valid and acted to pass the freeholder's interest to me as a complete conveyance. In actual fact, what had happened was that the Waterhouse Family Trust had the wrong vendors on there. There was some irregularity with that. So in actual fact, that didn't pass the interest to me, what's called the equitable interest to me. But Justice Bell was clear in saying that if they had the correct vendors in place, then that would have been an effective conveyance to me of the interest of the vendor. Now, the interest of the vendor is different from the interest of the bank. So we're getting into equitable and legal titles here, or equitable titles and legal interests. Sorry, legal titles and equitable interests. But really the equitable interest is the most important for you and I, because that's the part of the transaction that allows tenure to occur. It allows occupation, possession, use of the land, etc., etc., allows you to become the landlord, which is what I was saying right from the very beginning about the Crafar farms, that I was the landlord, and that's how it all started off. When I was saying, don't hassle my tenants, please, Westpac Bank. So it's I'm very excited about that judgment.
What does that mean for the Crafar farms?
Well, really, it validates those sale and purchase agreements that I made with the Crafars. It means that all it was left after the sale and purchase agreements were concluded on the 27th of August last year, 2011, all it was left for the bank to sell were the legal titles, which are the pieces of paper, which I described in the case before Justice Hanson as chattel paper. They're a form of property, and they are really what's marketed for money, because the handover of occupation can be done for no money or it can be done for whatever is considered to be consideration between the parties. Whatever the parties agree is good consideration, is good consideration. So the dollar has nothing to do with it. There's been not just one red herring in all of this, but a whole shoal of red herrings, if you like. So yeah, I'm really excited and really pleased. And moving forward for the Crafars, the next thing I will be looking for is investigating claims for repossession of those farms. I won't be moving on to any of the farms. I couldn't manage a backyard, let alone a farm. So there will be tenants moving back onto those, but those farms will not be passing out of New Zealand hands at all, and probably not out of the title of Mr. Crafar. His companies are still on those titles. Whether the the companies themselves dissolve, that may be the case, but the thing is that those farms still belong to the titles. Belong to Mr. Crafar, and the farms themselves belong to me.
Oh, that's good news.
Yeah, I think it is.